welcome to this British American Businesses Council for New England event. Since 1986, the Council has been dedicated to helping US and UK companies succeed in their transatlantic business endeavours. For details, please check out the website at www.babcne.org or contact Ursula at the Council's offices at the email address business@babcne.org. So, by way of introduction to this panel discussion on data protection and the death of Privacy Shield, I thought I'd introduce myself and obviously the panelists. My name's Alex. I'm a managing consultant working at the Chaucer Group in the UK, and I head up the cyber practice in the UK. We're a fast-growing consultancy that I've got for over 30 years now. We've been supporting clients going through digital transformation, their digital transformation journey. And I'll be your moderator for this discussion today. I'm going to move on to the panelists. Paul, do you want to go first and introduce yourself?
Certainly. Thank you, Alex. My name is Paul Gillingwater. I'm the head of the data protection practice within Chaucer, and I've been working in data protection for several years, and before that, cybersecurity and risk management. Allow me to pass on.
Thanks, Paul. Debbie, do you want to introduce yourself?
Sure, thank you. My name is Debbie Zoller. I'm a partner and co-owner at Schrems II. Schrems II is a CPA firm that focuses on security and privacy assessments and certifications. So I manage the Midwest region for Schrems II, as well as the privacy service line and SOC 2.
Excellent. Thanks, Debbie. Welcome personally from me, as we're really interested to get into that US perspective, as we've had lots of discussion on this kind of thing on our side of the Atlantic. It'd be really good to hear from your side as well. And lastly, and definitely not least, Claudio, do you want to say a few words about yourself?
Thank you, Alex. Yes, my name is Claudio De Paoli. I'm responsible inside BIP, that is a consulting company, a multinational consulting company. I'm responsible for cybersecurity practice. A team of more than 170 professionals that works in different spaces, and definitely compliance and privacy in Italy and in Europe is one of the big jobs that we're trying to address for supporting our customers.
No, absolutely. So welcome, Claudio, as well. And thanks, everyone. So today we're going to touch on hopefully 2 or 3 topics and get a really good feel from the UK, US, and obviously EU perspective as we chat, or as rather the panelists chat. If you do have any questions, please feel free to put them into the chat room, and hopefully we'll have a little bit of time at the end of the show to go through some of those. As a way of setting the scene, perhaps, Paul, you can explain a little bit from your knowledge and perspective on the impact of the recent Schrems II decision in July on transatlantic business.
Thank you, Alex. Yes, certainly the Schrems II decision has generated a lot of controversy, but it's something which has been also a long time coming. It was back in 2015 or 2016 that the Privacy Shield was first established, and there were doubts raised at that level. It was the replacement to the so-called safe harbor arrangement which preceded it, and it was an attempt to provide reassurance to European businesses, including the UK businesses, that American companies were safeguarding data appropriately. So the whole point of the Privacy Shield is that it was set up by the US Department of Commerce to protect the rights of Europeans when their data is transferred to the United States. And basically the arrangement requires American companies to annually self-certify that they meet the requirements of the Privacy Shield and to display a privacy policy on their website. The Privacy Shield restricted access to European data that's being held by US companies and forced, in theory, those companies to be more transparent in the way they are dealing with that data. Now, there were several problems with that from the beginning, and this was highlighted by an Austrian privacy campaigner by the name of Max Schrems, who 2 years ago, or actually more than 2 years ago, back in 2018 in May, when the GDPR first went into effect, he was one of the first to lodge a lawsuit and complaint through the Irish Data Protection Agency regarding the efficacy of Privacy Shield in regard to the disclosures about, or allegations from Edward Snowden about mass surveillance that were taking place supposedly by the FBI and the National Security Agency. So based on these allegations of mass surveillance, there were certain weaknesses that were thought to exist in terms of the protections. And so basically you got a dynamic tension between, on one side, the desire of American intelligence agencies to keep their citizens safe, and on the other, the great desire for European regulators and European governments to protect the rights of their citizens. That's where the tension came from. So that's a little bit about Privacy Shield. I don't want to take up all the time. Let me hand over to Debbie.
Great, thank you, Paul. You know, this is an interesting world that we live in today with lots going on this year in 2020. Everybody will probably be happy when this year is over. But I will say that, you know, this Privacy Shield invalidation is really having a huge impact on organizations and their privacy programs. You know, really for a while, organizations in the US have been struggling with different privacy laws, not only in the US, across the states, but also abroad across many different countries, adopting their own privacy regulation. So it's really a challenge for multinational organizations to comply with so many different privacy laws within their jurisdiction. And while you mentioned, Paul, there was news that the Privacy Shield, might be invalidated, it's really still come as a surprise without really any approved mechanism in its place. So now organizations that relied on Privacy Shield are kind of scrambling to obtain the next best transfer mechanism ahead of any guidance or really solid alternatives to avoid penalties. And you know what, we're in a digital society right now, especially more recently with COVID-19, and worldwide data transfer is a must. And so information is really coming out daily on this topic. There's really not a real solution that's yet available, but the EDPB has stated most recently that they've developed a task force to provide guidance from the EU, in addition to revamping the standard contractual clauses, hopefully by the end of this year, and working on a new data transfer mechanism. So companies in the US are really paying close attention to this news, while still ensuring compliance with the framework that's no longer valid in the EU and the Switzerland, for example, but is still being enforced by the FTC. So that's kind of the starting point for US organizations. Claudio, what are your thoughts from the EU?
Yeah, first of all, thank you to you and to Paul to describe the complexity of this decision. I mean, it's a matter of fact that the European companies now need to find out, let's say, a new way to manage this transfer of data. I mean, we all live in this incredible digital transformation. So it's not an easy task, because there are really many companies, I mean, from small and medium business up to multinational company that now is relying on big vendor, big service provider, big cloud provider, digital provider that are managing the data, let's say, on behalf of many organizations. What I would like to underline is that, I mean, we are assisting many customers in Italy and in Europe in this kind of compliance journey against GDPR. I had, let's say, the opportunity also to meet the father, Giovanni Buttarelli, of this regulation, because he's an Italian guy. And I think one of the key principles of this regulation is it's really a matter of risk management. I mean, many organizations need to now face how to struggle, how to manage the risk of managing personal data on behalf of the citizen, and look carefully of all the choices, including the one that, let's say, seems to be pre-approved, like the Privacy Shield. No one probably did, let's say, any thoughts about this kind of, let's say, impact that now we have with this decision. Some of them in the past and now are looking for example, some security measure like the cryptography in order to avoid, in any case, even if you have an agreement, that this kind of information could become available to someone that should not manage in a different way, according to the specific allowance that the citizens will admit to you. So my only thought is that this privacy journey is really complex and require, let's say, a risk approach that is probably, let's say, the new things that many companies need to look very carefully in this program.
That's really interesting, Claudio. Especially around the complexity, as you say, the risk approach, and maybe we'll circle around to that complexity, maybe into a little bit about the technology as well later on. But Debbie, you mentioned privacy programs, and I guess within that there's certification and compliance issues, etc. Can we explore a little bit more into that area?
Absolutely, yes. This really is having a big impact on organizations' compliance and certification, and really managing these complexities while maintaining compliance. As Claudio noted, it's really based on risk, right? And each organization is really going to have their own unique challenge. I mean, even the EDPB said there's really no silver bullet, right? There's no standard for all. So we're currently in the middle of several different assessments, certifications with our clients, and we're having discussions about, what can we do next, especially for those organizations that are currently relying on Privacy Shield, or even if they're relying on standard contractual clauses. We're talking about reviewing those contracts to determine if they're sufficient enough, which obviously is a very complex topic since we're not sure, the future of standard contractual clauses either. Most listening to this podcast are probably familiar with GDPR, but there are a few other privacy assessments that we're working with clients, including the ISO 27701, and then, of course, the APEC privacy certification. For those that aren't really familiar with the ISO 27701, it's actually a one-year-old privacy standard that's an extension of 27001. And it requires a privacy management system in addition to controls focused on the processing of personal information from a controller and a processor standpoint. So it's really a great worldwide certification on privacy because it is very flexible to the jurisdictions that are applicable to an organization. So rather than having specific requirements within the standard, they're very flexible to the jurisdiction. And then the APEC privacy framework was developed by the Asia Pacific region that includes the 21 countries that touch the Pacific, including North America and Latin America. This framework aligns with the OECD guidelines and international privacy standards. It includes privacy requirements, data transfer, and accountability for both controllers and processors. Currently, there are 9 participating economies, which means that these countries' regulators have mapped their privacy laws to the framework. And so they back the certification relating to their privacy laws for that more harmonized approach across the borders. So this certification is great because it includes both privacy principles as well as a data transfer mechanism. So really within these 2 privacy certifications, there are requirements for transfer. So data transfer, of course, is big in all of these, similar to the GDPR. And it requires things like recording of transfers, requirements for any data transfers to be legally binding. And that includes, ensuring the same set of privacy principles that are enforced by the data exporter. So, in light of this data and validation of the data transfers between the EU and Switzerland and the US, we're discussing some following next steps with our clients. So first, if you're currently relying on the Privacy Shield, ensure that you continue to maintain compliance until it expires. Second, you really want to perform a transfer impact assessment, and then definitely look at reviewing Article 49 of the GDPR for any applicable exceptions that relate to your organization. And then third, either review or implement standard contractual clauses that include adequate safeguards that appear to be most consistent with the EU protection laws. And, to perform a transfer assessment, you really first have to know what data is being collected, where is it being collected, where is it being stored, what countries or organizations are sharing that data. So if you did a data inventory or maybe data mapping a while ago, it's time to review that and paying close attention to the transfer of data. And then you really have to determine the legal basis for that transfer, meaning, was it based on consent from the individual, which is likely, and not in most cases. It's very difficult to do that. But you also want to come up with scenarios for when that legal basis changes. And then finally determine the recipient country's enforceable data subject rights or legal remedies. An organization should also document what safeguards they determined were adequate based on those risks that were identified. So it's basically essentially a risk assessment. But Paul, what are your thoughts from a UK perspective?
Well, one of the things that you rightly identified is the importance of carrying out a detailed assessment of the risks associated with the transfer mechanisms which are currently being used. One of the things which may be helpful to remember is that when you carry out such an assessment, there's no guarantee you're going to get the answer you want. You might find that your assessment says, actually, we can't protect the data. We've got metadata, we can't encrypt it. The key management is not ideal. There are problems with that. And at that point, you are obligated to go to your supervisory authority and say to them, look, we've carried out a transfer assessment. What are your recommendations? And they may give some recommendations. They may refer you to the European Data Protection Board, which so far hasn't been terribly prescriptive in terms of the findings. But I know, for example, that they're working on replacements for standard contractual clauses, which were also potentially invalidated. And so ultimately, you've got to seek around, get appropriate advice, and just do the best you can with the mechanism. Privacy Shield, however, it's an ex-parrot. It's dead. It can really no longer be relied on safely. And my feeling is that regulators probably won't come down too hard on American companies which are still adhering or depending on Privacy Shield. However, that doesn't mean to say it's risk-free. If you choose to continue to use an invalidated transfer mechanism, it opens you up to potential class action lawsuits. And if groups of large numbers of customers find an appropriate sympathetic judge's ear in either a US or a European court, it may well be that you get a nasty surprise and find that actually these laws can be used in private lawsuits as well as government enforcement.
I agree with Paul. I mean, the complexity is very high. What I would like to add to the discussion is we assist many companies that are multinational, and they have presence in different geography. They have, let's say, people in different geography, and they need to rely on regulation of different geography. And privacy is not, let's say, only GDPR. It's also PII. Is also, there are many now nations that are regulated in terms of how to manage the privacy data, but there are many other regulations. So one of the things that is really difficult for this kind of companies, how to go through a valid program, how to maintain, let's say, a group level and a local level rules and processes, but at the same time trying to comply with all the regulations that are, let's say, established in each and every countries. I think one of the topics is the one that Debbie already touched. I mean, there are now standards like the ISO 27001 and, let's say, the specific area of privacy that is the 27701 that is at the worldwide level recognized. So this can really facilitate the way the company, this kind of companies, can manage to have, let's say, a personal data protection systems that can be used at the worldwide level. We always, let's say, rely on this kind of guidelines. As an organization, we develop a specific control framework that is based on ISO 27701, but also in ESA guidelines, also the CNIL, that is the privacy authority from France, and a specific Italian company that is already providing a schema that is, as you probably know, there's no schema already authorized for certification in GDPR, but they are waiting for any green light to certify their schema. So I think it's not an easy task for, let's say, organizations that are multinational today to understand how to manage not only the issue of GDPR itself, but how to comply with the, let's say, rights and freedom of all the citizens they need to serve. In a way is compliant with all the regulation that they have. So just to add, let's say, another point of view on this complex matter.
That's really interesting, Claudio. It's three very different aspects there, and in that brief discussion on privacy programs, we had really solid practical advice, and also the advice of Monty Python, which is superb. So, Claudio, you mentioned earlier about the complexity, and also in response to that last question about complexity, I know that you have a background in technology as well. I'm just wondering if you can sort of go into a little bit more detail on your views in terms of the need for technology in the modern day, especially with the background of Schrems II, Privacy Shield, etc.
Yes, we spend a lot of time in supporting customer, and we are still spending time in protecting, let's say, their business first, but also personal data as a consequence of this kind of compliance regulation. There are two main, let's say, streams. The first stream is how to use technology to protect the data, but I don't want to go in deep in this area. Maybe, let's say, Debbie and Paul can touch them. We recently used technology in order to specifically build a platform. Why? Because talking about the complexity of supporting multinational company, or just, let's say, company that are several legal entities. It could be also in one specific country, but with different legal entities, with different people that work for this legal entity, with different stakeholders and third parties and service provider. The compliance journey is very complex, and in many cases supported by many different kind of consulting company. So what we suggested is to use a strong methodology and to adopt the same methodology in all the different groups and legal entities. It's really helpful to have a platform, and the platform can help you first in have, let's say, the same kind of process to go through, no? Starting, for example, for data mapping, that is one of the struggling of this kind of job. I mean, when you touch personal data, maybe you don't know that a car position is a personal data, or could be a personal data, or the IP address of an employee could be a personal data. So it's not an easy task just to identify the personal data and then go through the data impact assessment. Maybe you are a life science, let's say, company, so you touch very critical data, and you need to know, let's say, how to protect this data compared to other kind of data, and then go through the real risk assessment, the one that suggests you a framework of protection technologies that you can use in order to mitigate the risk of unauthorized access, or even, let's say, to compromise the integrity of some data. All these kind of tasks can be managed by a platform, and you can track all the stakeholders that work on this program, because another important principle of GDPR is accountability. So you need to have people that take their responsibility in deciding things through this program. So it could be a processor, but it could be just, let's say, a person inside your organization who is delegated to do such a job. So what we suggest is use a strong methodology first, because technology itself is not useful to anyone, but then enforce this methodology using a platform that can really simplify the journey. It can align many different kind of culture, because it's also in a multinational area, this kind of issue to an obstacle to manage, and to have the same approach certified by a platform. So I will leave to Debbie and Paul, because technology, I think, it's pervasive in this matter. So
Claudia, you bring up some really good points. I really like your point about, especially with several different legal entities developing one methodology and one platform. Certainly that's a challenge in and of itself, but I think that's a great way to at least set kind of a baseline. And as you mentioned, I mean, technology essentially is going to play a huge role in compliance and certification. I mean, just looking at data inventory, maybe performing your transfer impact assessment, technology is going to be necessary, right, to do that. And organizations might even decide to just keep the data in the member state rather than transferring it out to the US. So that's another technology point that a lot of organizations are thinking about. And I think you finally also touched on this as well, is maybe, cryptography, right? And rendering the data unreadable such that surveillance maybe really wouldn't even matter. And maybe that's an adequate safeguard for some organizations. So, really technology, I think, is going to be behind all of these legal and organizational measures. I mean, it's really the backbone of certification and compliance. Paul, what are your thoughts?
Yes, I'm a little bit skeptical about the ability of cryptography to protect data, given that if you turn up at the home of the person who holds the keys with a baseball bat, you'll usually get the keys pretty quickly. So, and this brings us to another point which I feel quite strongly about, and that is that this isn't solely a technology or compliance issue. When we're thinking in terms of risk, there are really two very broad and different categories of risk to consider. One is the technology risk, the risk of unauthorized disclosure of information, of changing or inability to access information. But the other and more important aspect is the risk to the rights and freedoms of individuals. This is the beating heart of the GDPR regulation. It's the basis on which it was formed. And that's why the European Court of Justice found, as it did, that both the Privacy Shield and indeed the standard contractual clauses may not be adequate to protect those individual rights against any government, it just happens to be that the US is the largest target, but let's not be fooled. All governments with the capability are engaging in any sort of surveillance they can. And I would just note that a court held this week that the actions of both the FBI and the NSA were illegal in terms of US law as well, and not just finding itself in conflict with European law. So there's plenty of things to talk about, and we're going to see some significant changes. Facebook, for example, is going through the process of whistling as they pass by the cemetery in one term. And they're emphasizing that they're protecting the data. And the question is really going to be, whom do you trust with your personal data? And that's a decision that ultimately each one of us will have to make. And it may be that we do need to trade our personal rights and freedoms against certain privileges or access. Why do people use Facebook? Well, it's a tremendous tool for bringing people together and sharing information. And like any tool, it can be abused. So ultimately, it's a choice that each of us need to make. And the goal of consultants will be to help companies to comply with the law, but hopefully to recognize that there are benefits for companies and businesses to protect the privacy rights of their customers. And those are the companies which are going to do better in the long term. What do you think?
Yeah, I would agree with you, Paul. I mean, you made a lot of good points there. And I think that really the overarching point for me is that, since GDPR's inception, we had in the US here, we had one of our most comprehensive privacy laws being the CCPA in California. Other states are following suit, but worldwide, we're seeing countries develop their very first data protection laws. So I think as a whole, worldwide, we are taking a closer interest in privacy, especially in the US, where we didn't necessarily think about privacy as much as freedom, as you mentioned. We appreciate those tools like Facebook, but now we're taking a closer look at, what are they doing with our data? Consumers are starting to ask the questions, how much information do I need to give to an organization? What are they doing with my data? And who are they then selling it to? Who am I going to have phone calls from down the road that I didn't want or didn't consent to? So I think now it's really interesting. While it makes it a very complex privacy world, it's really created awareness worldwide, and we're starting to ask those questions because of it. And I think those are great questions that we should be asking. Claudio, what are your thoughts?
Yes, I think you touch very, let's say, interesting point. I mean, the good things of this matter is that we are discussing something different from the past. I mean, if I'm talk to many customers now, let's say they bring another point of view on how to manage the data in a way it could really, let's say, protect the rights and freedom. That is another, let's say, point of view that no one before did, let's say, manage. And I agree with you. I think the awareness, this is also valid for cybersecurity, is the key. I mean, there's no, let's say, so much information and awareness on these two topics, cybersecurity and privacy. And we really need to, let's say, to do a lot of job in spread, let's say, the information about these topics and force people in thinking about and grab their point of view, because this will change the way an organization can manage autonomously, without even some consultant, the privacy, rights, and freedom. So it's not an easy step. I think we just started to do, but I think now is because of the digital transformation is a global problem. It's not anymore. I mean, it's probably, let's say, suggested from European, but any countries now are developing their own, let's say, privacy regulation, and many of them are, let's say, go through similar article of GDPR. So I think it's a challenge for every person as a citizen. So to ask which kind of, let's say, service should I trust in order to give my data, and it's also from company that need to try to protect as much as possible the interest of their customer at the end of the day, so their people.
I think that's a great place to actually draw stumps for the day. I mean, obviously, the discussion on data protection is one that I'm sure that we could keep going into the wee hours of the morning. But I really like the finishing point where the data protection is not just about being a legal requirement. It's a business enabler, and it's becoming more and more a decision-making factor for the consumer, for the customer. So actually, Privacy Shield or otherwise, data protection itself should be regarded as a business enabler. So I think this is the right time to draw a line on today's discussion. It's pretty clear to me that there's opportunity for further talk, and obviously for our listeners and watchers. I'm sure that the discussion has probably raised more questions than it's given answers, unsurprisingly. I mean, the ramifications of those recent decisions are so potentially far-reaching, and it goes, as you all mentioned, beyond GDPR. But I think one of the areas that we haven't touched upon so much in this chat conversation that perhaps we've parked, but we should talk about possibly in future times, is maybe Brexit and the implications of Brexit. And I mean, we've all seen the UK government's decision just within the last hours, if not days. And perhaps as we move forwards towards the end of the year, we might reconvene to discuss that a little bit more, because I think that would be an interesting conversation. But in the meantime, so anyone that's watching this podcast, please feel free to get in touch with us if you'd like to explore any of these topics further, or even the wider data protection and cybersecurity. Our contact details will come up after the show, and we'll be on the website as well. And we're looking forward to hearing from you. But for now, we've got a few minutes for questions, and so I'm just going to see if we've got any.